Good morning. My name is Deputy Corporation Counsel Sylvia Wan. This is the Board of Appeals meeting dated February 14th, 2025. This hearing is being held both in person at the Kona Council chambers as well as virtually using the Zoom platform. Since our last hearing, our chair has resigned, leaving the Board of Appeals with no officers to run this meeting. So at this time, I will facilitate this hearing to allow for the election of a chair pro tem, also known as chair for the day. Before I request a motion for a chair pro tem, can I please have the board members introduce themselves for the record, starting to my left? Oh, I'm sorry, starting to my right.
Board Member Rachel Abel.
Scott Martin.
Now to my left.
Board Member Stacy Aguiar.
And now to Zoom, Lisa,
McNamara.
Kathy.
And Kathy Lewis, board member.
Thank you very much. I will also note the presence of myself, Deputy Corporation Counsel Sylvia Wan. I am the board's attorney. We also have Bethany Morrison, staff to the board, as well as Ashley DeVera, the board secretary. At this time, can I please get a motion for a chair pro tem, please? Please note that you can self-nominate.
Board Member Stacy Aguiar, I'm willing to chair pro tem for this meeting.
May I get a second?
I second that motion.
I'll note a second by Rachel. Please open for discussion. Any discussion? Hearing and seeing none. Can I please call for the vote? Bethany?
This is on the motion for Chair Pro Tem. We'll start with the motioner, Stacy Aguiar.
Aye.
The second, Rachel Abel.
Aye.
Board Member Kathy Lewis.
Aye.
Board Member Scott Martin.
Aye.
And Board Member Lisa McNamara.
Aye.
Chair, you have all ayes.
Thank you. The motion carries. At this time, I'd like to congratulate our Chair Pro Tem, Stacy Aguiar. I will now turn the meeting over to you.
Thank you. So before we begin, I'd like to review some online protocols and in-person protocols. If you can please have all cameras turned on at all times during the hearing. One person should speak at a time with no side conversations. Keep your device muted when you're not speaking to improve audio quality for all. Raise your hand and wait for recognition before speaking to ensure we make a clean and clear record. And prior to speaking, please state your name so that all parties know who is speaking. Speak slowly, clearly, and be close to your microphone. Limit distractions by turning off mobile phones and other devices. And as a general reminder to all of our BOA members, please state your name before speaking throughout our hearing today. At this time, we will move into any statements from the public on any of the agenda items. If there are any public testifiers, they can testify now or prior to the agenda item in which they wish to testify. Bethany or Sylvia or Ashley, do we have any public testifiers today?
No public testifiers.
Okay. We have no public testifiers, so that concludes the public testimony portion of this meeting,
We're at this time.
or at this time. So moving on to old business, if we can move into case number 1, David Heffer, BOA 19-000206-C, appeal of planning director's decision denying application for short-term vacation rental dated August 27th, 2019, location 82-953 Coffee Drive, Captain Cook, Hawaii 96704. Bethany, do we have any public testifiers on this agenda item?
No public testifiers.
Thank you. So if I may start by getting the names and appearances of the parties for this matter, starting with the appellant, which I believe is on Zoom. So if Mr. Heffer's team can please introduce themselves.
Hello, David Heffer.
Thank you. And for the planning department?
Good morning. This is Deputy Corporation Counsel Jean Campbell, and with me is our Planning Director, Jeffrey Darrow.
Good morning.
Morning. Thank you. So one housekeeping matter, if we can ask the board staff if the appellant has provided notice of hearing to the surrounding property owners pursuant to our Rule 8-11D and proof of service has been filed.
Yes, Chair, this was filed on January 24th, 2025.
Great, thank you. Let's proceed with our hearing. So I'll let both sides know that we have read the record in this case. And with that in mind, do not repeat what you have already provided us, and know that the board has read all materials thoroughly and is ready to hear their case. There's one legal issue before this board, whether the director's decision in question should be reversed or affirmed. With that, let's begin. The board will now hear opening statements from the parties. Please keep your statements to 10 minutes or no more than 10 minutes. And at 2 minutes, Sylvia will be keeping time and will announce as such that you have 2 minutes left. And if we may start with the appellant, Mr. Heffer.
Yes, hello, good morning. This is going to be very short. As first, I think if you read the materials, this is the very likely last step for a federal court filing in this case. As you might have read in that email, my legal team here in New York City is considering adding, punitive damages charge against the county in the court filing. And I'm just, don't want any surprises from the board members. Those you might be personally included in that punitive damages filing. All of you board members, I want to remind you, I know it's in Mrs. Campbell's brief that you should not consider the constitutionality of the ordinance which led to this filing. You all have an oath of office, which you did initially when you joined this board. I just want to remind you of the oath of office. So I disagree with that point in Mrs. Campbell's filing. And the third one is in the concrete point of this meeting compared to the meeting which was 5 years ago or more than 5 years ago initially. It really is about vested property rights in this, not only for my property, but for the entire McCoy plantation in this part. And if it is in the materials, this is where we have a single family home, not a farm dwelling. That's it. Thank you.
Thank you. And for the department, an opening statement.
Good morning, Chair Aguiar and board members. I'm Jean Campbell, Deputy Corporation Counsel representing the Planning Department. With me today is Director Jeffrey Darrow. This case is one of the remaining matters from the initial implementation of the county's regulation of vacation rentals, a process which began in 2018. While the history leading up to today is long, this case is actually pretty simple. To provide you with some helpful context, I'll explain a little of the history of the county's regulation of short-term rentals. Michael Yee, the planning director in 2018, initiated the process to regulate vacation rentals. Understanding the need to take the process one step at a time, this first proposed regulation covered only what were informally referred to as unhosted vacation rentals, or rentals for a short period of time where no one lives permanently on the property, because that's where most of the community complaints about vacation rentals arose. Like all other duly enacted county code, Bill 108 was enacted by the county council following many public hearings and much public discussion. In the case, both at the planning commissions and at the county council. The new code defined short-term vacation rental as having 3 elements. No owner or operator resides on the property. No more than 5 bedrooms are being offered for rent. and rentals are for a period of 30 days or less. The new code allowed short-term vacation rentals outright in some zoning districts, subject to to registration requirements and operation standards. Owners who had been operating STVRs outside of the permitted zoning districts prior to April 1st of 2019 were required to obtain an STVR non-conforming use certificate, or NUC, in order to continue their operations, and the NUCs had to be applied for by September of that year. Notably, agriculturally zoned areas were one of the areas where NUCs would be required, and Section 25-4-16.1E of the County Code specifically stated that in the state land use agricultural district, a short-term vacation rental non-conforming use certificate may only be issued for single-family dwellings on lots existing before June 4th of 1976. It's important to step back and understand a little bit about how Hawaii land use regulation works. Hawaii has a two-tiered land use scheme. We have our county zoning districts, which get into a lot of detail about uses and lot sizes and the likes. Above the county zoning is our state land use districting structure, found in the Hawaii Revised Statutes, Chapter 205. The state scheme has only 4 different districts: conservation, urban, agricultural, and rural. And rural is intended to be the interface areas between urban and agricultural. As with all state law, the state law supersedes county law. In the case of the land use law, this means that the county cannot permit uses in a state land use district that the state land use law does not already allow. In drafting Bill 108, the county took note of the state law and determined that there was a change in state law as of June 4th, 1976, which limited the way that land in the state land use agricultural district could be occupied. Originally, the state law allowed for single-family dwellings, but as of that 1976 date and going forward, only farm dwellings were permitted. There's an important distinction between these two types of uses. While the physical structure itself might be exactly the same, a farm dwelling has specific use restrictions, which a single-family dwelling does not. A farm dwelling must be occupied only by a family who's either engaged in farming on the property or is deriving their income from farming done by others on the property. The county determined that there was no way for short-term renters to either be engaged in legitimate farming or to derive their income from farming if they were staying in the rental for only 30 days. I note that the state law does have provisions for farm workers who may stay for short periods on ag properties, but that wasn't the use that was anticipated by Bill 108. So just to make sure that no one's confused, the state law does allow for, and Bill 108 does allow for short stays by legitimate farm workers. But in the case of STVRs, they were specifically defined as no one lives on the property, so the only people available to comply with the state law would be the STVR renters. So to get back to our circumstances, the county denied all of the NUC applications that it received for properties on state land use ag lands where the lots were formed after June 4th, 1976. A number of these owners appealed, including Dr. Heffer, and seeing so many of these appeals all at once, a number of the appellants and the county agreed that it would be worth asking the State Land Use Commission, the body that makes determinations about state land use law, whether the county's position was correct. A group of these appellants consolidated their appeals under the name of one appellant, Linda Rosehill, and both the Rosehill group and the county submitted declaratory petitions to the State Land Use Commission. And all of the NUC appeals were stayed at the BOA to allow that state process to play out. Several years and multiple court proceedings later, the Hawaii Supreme Court finally ruled that the county was correct, stating specifically that the county's ordinance is consistent with state zoning and that farm dwellings may not be used as short-term vacation rentals under HRS Chapter 205. With the issuance of the Rosehill decision last fall, the NUC denial appeals have come back to life at the BOA. Today's case is the first and likely only of this group of appeals that you're going to be seeing. At issue today is not whether the county code was properly enacted. It was. Today's appeal has nothing to do with whether the state or the county has conducted reviews of state land use boundary maps or proposed changes of those maps. Those are all matters well outside the authority of this body. At issue today is simply whether the county decision to deny Dr. Heffer's application for a NUC violated the law was clearly erroneous or was arbitrary and capricious, an abuse of discretion, or an unwarranted exercise of discretion. As the director will explain, Dr. Heffer's lot was formed in 1979 and is located in the State Land Use Agricultural District. Thus, regardless of what the physical structure of his home looks like, his application was properly denied pursuant to County Code 25-4-16.1E because, as the Hawaii Supreme Court ruled, farm dwellings may not be used as short-term vacation rentals under Chapter 205. Thank you.
Thank you, Ms. Campbell. And so thank you for both of your opening statements. And at this time, we will proceed into witnesses. If Mr. Heffer, do you have any witnesses?
No witnesses.
He can call himself.
Would you like to call yourself as a witness? This would be your opportunity to speak.
I think everything is in the papers provided.
Okay, thank you. So then we will move to the department. Do you have any witnesses you'd like to call?
Yes, I'd like to call Director Jeffrey Darrow, please.
All right, Sylvia, would you like to swear in?
Yes, Mr. Darrow, just for ease, can you sit over here? Just so that we can formally consider you a witness? And you may need to turn on that mic once you're settled. Great, thank you. Can you please raise your right hand? Do you promise to tell the truth and nothing but the truth before this board today?
I do.
Thank you. You may proceed.
Good morning, Director Darrow. Since this is your first appearance before our Board of Appeals as the new planning director, would you give us a brief introduction to your planning background?
Sure. I have been with the County of Hawaii for over 32 years. I started with the planning department in 1998 as a zoning inspector. I've been with the planning department for over 26 years. From being a zoning inspector, I had held numerous positions within the planning department, including Planner 4, Planner 5, Planner 6, Planning Program Manager, Deputy Planning Director, and now Director.
Great, thank you very much. It's good to know that you have such an extensive experience with the county. So since you were in the planning department in 2018 and 2019, can you briefly describe for us the process that the county followed in 2018 and into 19 to begin regulating vacation rentals?
A ordinance or a bill was drafted by the county council, Bill 108, and this was in the beginning part of 2018. The intention was to regulate what we call short-term vacation rentals. There was an effort to consider doing both what we call unhosted vacation rentals as well as hosted, all in one bill. But as we began to work on it, we realized that that was just too much to chew off at one point. So the focus of Bill 108 was on the more impactful type uses that were occurring with unhosted vacation rentals. The bill was introduced by two council members, Councilmember Karen Eoff as well as Councilmember Kanuha. It went through extensive public hearings. There were over 400 bits of communication that were added as part of the record. There were 7 drafts to the bill, with draft 7 being the one that was ultimately adopted. This was signed by our Mayor Harry Kim at the time in December of 2018, but the effective date was April of 2019. That was to allow a period of time for the planning department to create planning department rules for the process of being able to register both permitted STVRs as well as what we call non-conforming use certificates. That process began in April of 2019 and went until about September, but it actually went beyond that. You just had to have your application in within a particular time. I recall there being thousands of applications. During the planning department rule, there were also public hearings both on the east side and the west side. So there was a tremendous amount of public outreach and participation.
Great, thank you. So is it fair then to say that Bill 108 went through the same process that every other code amendment does, only arguably this one had more public input than usual?
Yes.
Okay, great. Can you tell us what is a building site?
That is actually defined within our zoning code under the definitions, and I can read it if that would be okay.
Sure.
Building site means a parcel of land which is occupied or is to be occupied by a principal use and accessory uses, or a building or group of buildings, and includes a lot and a plot.
Great, thank you. So looking at the broader STVR code, why did the county include section 24-4-16.1E, which says that no NUCs would be issued on lots formed after June 4th, 1976?
As mentioned in your opening statement, we have a dual system of land use. We have the state land use law and we have the county land use law. The state land use law at that particular time said that an allowable use on state land use agricultural districts were farm dwellings. A dwelling had to be related to, it had to be in connection with a farm, or it had to have agricultural income. But there is a portion in the code or in the law that says on lots existing prior to June 4th, 1976, the dwellings were considered single-family dwellings, not farm dwellings as defined in state law. And so through the adoption of the bill or the creation of the bill, that was a very distinct matter that we were trying to work through. There was suggestions not to allow STVRs within the agricultural district period, but it was clear through all of the discussions that happened that they felt that because there was that clear distinction between a farm dwelling and a single family dwelling, and that clear date of June 4th, 1976, they would create a section in the law or in the code for non-conforming use certificates, which were only to be allowed if you were operating prior to that date and if you received a certificate that was required evidence that you were operating to then. So that is the reason why you'll see that within the section of code.
Thank you. So to summarize, that section was included because the county recognized that farm dwelling requirements would not allow for a use that specifically said no one lived on the property. And the issuance of non-conforming use certificates would be a way to grandfather what was previously a legal use.
Yes.
Okay, great. So looking back at the process that the county went through to implement Bill 108, focusing on the letter that the planning department provided at the request of council in November of 2018, is it unusual for the department to provide general background information and education to help the council understand possible effects of bills that they're deliberating on when they're considering code changes?
It does happen. It doesn't happen often, but it does happen.
Okay, great. So in a case of a communication like the November 18th letter, which was a general survey of subdivision status issued to the council, should a particular lot owner expect to be able to rely on a letter like that as a formal determination applicable to their particular lot?
I would say no.
Okay, great. Thank you. So stepping back a little bit, just to understand how our land use law works. What is the effect of a rezoning on a particular property? And this is just a general rezoning, not anything in particular. What's the effect of a rezoning on a particular property once it passes the county council?
What happens in a rezoning ordinance is an existing zoning is requested to be changed. Most times that change is to create a type of higher density. Using this particular application in rezoning, that was the request in this particular rezoning. The zoning was agricultural 5 acres, and the request was to rezone the property, which was larger at that point, to agricultural 1 acre and agricultural 3 acres.
Okay, great. So when that rezoning is passed by the council, specifically one that allows for increased density, does that actually change the lot layout, or is there a separate process for that?
The rezoning does not change the lot layout. It only changed the zoning for the property. There is a further process called a subdivision process that needs to be followed to create lots after that.
Okay, great. So the rezone allows for the possibility of creating new lots, but it doesn't actually do it. So then can you tell us a little bit about how the subdivision process works?
If somebody is wanting to create, they have a large property and they want to create smaller lots based on the allowable density of the zoning, they can submit a subdivision application, which usually includes an application as well as what we call a preliminary plat map, which identifies the proposed layout of the lots. It may include roads, easements, and different types of features on the particular property. Once we send it out for comments and we receive back comments and everything looks good, we issue what is called tentative approval, which has a list of conditions. In order for the applicant to finalize the subdivision, they have to do all of the particular conditions, which usually entails infrastructure improvements and any type of possible conditions that might have been attached to a rezoning that created the new zone.
Okay, great. So the initial formation of a subdivision, and correct me if I'm misstating this, the initial formation is getting that tentative approval. Once a developer has the tentative approval, they can go in and satisfy all the conditions like building out the roads or other things that may have been imposed either in the subdivision or the rezone process. And then they would come back again once they're finished with all those things and ask for a final subdivision approval. Is that correct?
Yes, and keep in mind that depending on the particular subdivision and the required improvements, that period of time could take some time to do.
Okay.
Sometimes several years.
Okay, great. In the case of what we think of as, a large subdivision, say a community that creates 100 lots, once that community is created, are there ever instances where individual lots within the community are changed later?
Yes, that happens on a regular basis where a particular subdivision was created originally, and then there's revisions to that subdivision in the future, which in turn changes the date of whatever the creation of the new lots that are formed are.
Great. So we could have an instance where a master subdivision has a particular date as a whole, but then lots are consolidated or re-subdivided, whatever, internally, and that would be the date for those particular lots rather than the master subdivision date.
Yes.
Okay, great. In the case of the McCoy Plantation subdivision in particular, can you walk us briefly through how that subdivision was formed?
From my review, sorry about that. Originally, as we had mentioned, a rezoning came in. The property was originally agricultural 5 acres. The applicant came in and rezoned the property to agricultural 1 acre and agricultural 3 acres. Subsequently, they came in for a subdivision to be able to subdivide a portion of the property, which I believe was part 1 or increment 1 in the subdivision. My understanding is that did not create the original lot 11. It did create a lot 11, but it was a bulk lot, which means the remainder of the property that was to be rezoned later. After that particular subdivision was approved, another subdivision was approved, and that created additional lots. And again, this is kind of a common practice where a subdivider may not subdivide the entire thing, but try to do it in increments, mainly because of the cost of doing all the improvements. But in this particular case, this was an incremental subdivision, which had different dates of approval of when those particular lots were formed.
Okay, so what was the formation date for Dr. Heffer's lot 11?
My understanding, and correct me if
Simply the
I'm-
year is okay.
April of 1979.
Okay, great, thank you. I think that covers enough about rezoning and subdivision. So looking at how the planning department handled all of the NUC applications that it received, you mentioned that on the whole, the department was inundated with all kinds of STVR applications. When the county received the NUC applications in particular in 2019, did the county approve any NUC applications?
Yes.
Okay, so what were the grounds for denying, or what were some of the grounds for denying the ones that were denied?
There were multiple reasons for denial. One of the main ones I would say was there's a requirement that this whatever building or buildings that are coming in with the application for the short-term vacation rental had to have final building permits. And so that was probably the most of the denials or rejections that occurred was because in reviewing building permit history and other things, we'd find unpermitted structures, or we'd find buildings that weren't final, those kind of things.
Okay, great. So the department essentially did a very complete review of each application it got. Did the county issue an approval, or did the county issue a NUC for any lot within the state land use ag district where the lot was formed after June 4th of 1976?
No.
No. Okay, so that was another grounds that we denied things.
Correct.
Great. Okay. So looking at this case in particular, did the county receive an STVR NUC application from Dr. and Mrs. Heffer?
Yes.
Okay. Was that approved?
No.
No. And can you give us the general basis for why?
There was one reason why it was denied, and that was the creation of the lot. The property was situated within the county's agricultural district and the state land use agricultural district. As mentioned in chapter 25, 416.1 E, if the lot was created after or existing after June 4th, 1976, then that was considered a farm dwelling and could not be permitted as an STVR.
Great. Thank you. I have no further questions.
Thank you. Mr. Heffer, would you like to cross-examine the witness?
Actually, yes. Just one question, as you've been in the planning department for a long time. Did you have colleagues in the planning department, especially the person who actually is the denier of the application, who are registered sex offenders?
Yes.
Yeah, you can ask.
So if I may qualify, I don't believe that question is relevant to the case. Do you have any other questions for the witness, Mr. Heffer?
No.
Thank you. Do any of the board members have any questions for the witness before he steps down? Seeing none. Ms. Campbell, if you'd like to call your next witness, and thank you, Mr. Darrow.
Thank you, Director. Yes, I'd like to, I have a few questions for Dr. Heffer.
Yes.
Dr. Heffer,
Hold on,
oh, you need.
Ms. Campbell, if Sylvia, do you want to swear Mr. Heffer in as a witness for the department, please?
Sure. Mr. Hepper,
Mhm.
can you please raise your right hand? Thank you. We can see that on the screen. Do you promise to tell the truth and nothing but the truth to the board today?
Yes.
Thank you. You may question the witness.
Thank you. Dr. Heffer, have you or your wife ever lived at your property located at 82953 Coffee Drive in County Cook?
Yes.
Thank you. Have you ever rented the property out to others?
Yes.
Okay. Was that rental either for longer or fewer than 30 days, or perhaps both?
Both.
Both. Okay, thank you. Did anyone live on the property while you were renting it out for periods shorter than 30 days?
No.
Thank you. No further questions.
Thank you. Mr. Heffer, as a witness,
Mhm.
would you like to make a statement since you technically can't cross-examine yourself, but have any more statements?
No. Again, the statement is, if you look at the ordinance, which was the last, approval needed from the county, where somebody voted on that, which was not ministerial in case, that was done in 74, and it specifically mentions the line is in the material that the rezoning allows for building permits for single family homes, not farm dwellings. So I think you all have the paper there where it exactly is mentioned in the ordinance from 1974.
Thank you. Do any of the board members have any questions for Mr. Heffer? Seeing none, Ms. Campbell, would you like to call your next witness? Thank you, Mr. Heffer.
I have no further witnesses. Thank you.
So we move into the closing statements or final arguments, and if we can start with the appellant, Mr. Heffer, do you have any closing statements or arguments?
No?
Thank you. And moving on to the department, any closing statements?
Yes, thank you. So thank you for giving us the opportunity to explain the background of this case. While the road that brought us here today may have been long and winding, the decision before you is very simple. In 1976, the state legislature determined that homes on land in state land use agricultural districts should be occupied only by families engaged in agriculture or deriving their income from agriculture. That decision by the state has been the law since then, and the county has no authority to supersede that and allow uses that are not already permitted by the state law. When the county enacted Bill 108 to begin regulating short-term vacation rentals, the county was obligated to comply with state law. That permitted the county to allow STVRs in some, but not all zoning districts. In compliance with state law, the county allowed for the issuance of NUCs on lands in the state land use agricultural district only if the lot was formed prior to June 4th of 1976, when single-family dwellings were permitted. The Hawaii Supreme Court has confirmed that the county's ordinance is consistent with the state zoning and has also held specifically that farm dwellings may not be used as short-term vacation rentals under HRS Chapter 205. In this case, the county has submitted exhibits showing clearly that Lot 11, owned by Dr. and Mrs. Heffer, has a final subdivision approval date of 1979. Thus, I would ask this board to recognize that the planning director's decision was compliant with state law and county law and consistent with all similar NUC denials. This board should affirm the director's decision to deny Dr. Heffer's NUC application. Thank you.
Thank you. That closes the hearing portion, and the board will now deliberate, and we will entertain a motion after deliberation. Any board members?
Do you want to take a 5-minute recess?
Sure. So we're going to take a 5-minute recess, and it is 10:11 a.m. We'll be back at 10:16 a.m. We're in recess. Thank you. For the record, we are extending our recess for another 5 minutes, and we will be back in session at 10:25 a.m. We are now back in session and back from recess. And we will continue with with her case, David Heffer, BOA 19-000206-C. We went into recess looking for deliberation or a motion from any of the board members on the evidentiary portion of what we've heard.
Board Member Rachel Abel, I make a motion to affirm the planning director's decision for David Heffer, BOA 19-000206C. The appellant did not sufficiently prove his claim that the director's actions state and court law in his decision, specifically his decision on that the lot was, sorry, couldn't read.
Rachel, would
Excuse
you
me.
like to restate your motion?
Yes, sorry. Read from there. Excuse me, let me start again. I make a motion to affirm that the planning director's decision, David Heffer's, I make a motion to affirm that the planning director's decision was not clearly erroneous and that decision was not arbitrarily or capricious, nor was it an abuse of discretion based on the fact that the appellant did not sufficiently prove his claim that the director's action were state and county law in his decision, specifically that he based his decision on that his lot was not created after 1976.
Member Abel, can I clarify your motion just a smidge?
Yes,
Okay, so what you're stating is that you're affirming the director's decision and the basis is you're claiming, or at least your motion is claiming that the appellant did not sufficiently prove his claim because the director's actions were not against law, in that the director specifically followed state and county law. Is that correct?
yes, that's what I was.
Thank you.
I'll second the motion.
Thank you. That was a second by board member Kathy Lewis.
Yes, sorry, I'll try to remember to say my name.
And so the board is now in discussion on the motion. Any comments or questions?
Rebecca, because you were the mover of the motion, do you mind just giving a statement or two to support your motion?
Because the law was set in place in 1976 and Heifer's property was 1979, because those dates were clearly set in place, that was the decision. That was the basis of my decision.
I'd just like to add that we rarely have a case with such clear and on point law from the Hawaii Supreme Court, especially on such a very specific issue. So I find that Mr. Heffer's lot falls clearly within the Rose Hill case ruling.
Thank you. Any other comments or discussion from board members? Seeing none, if we can take a vote, Bethany.
Chair, on the motion to affirm the planning director's decision, Rachel Abel,
Aye.
board member Kathy Lewis,
Aye.
board member Stacy Aguiar,
Aye.
board member Scott Martin,
Aye.
board member Lisa McNamara,
Aye.
chair motion passes.
Thank you. So that concludes this case. If I may ask the prevailing party, the department, to please issue the form of the order within 30 days, which would be approximately March 14th, and issue it upon all parties at such time the appellant, Mr. Heffer, or any other parties to this matter has 15 days after that to object or comment on the proposed form of the order. And that would be approximately due on March 28th. That concludes this case. Thank you, Mr. Heffer and the planning department for your appearance.
Thank you.
If we can move on to case number 2, Joaquin Belisario, PLBOA -2024-000101, order to dismiss appeal of decision by the Director of Public Works dated February 20th, 2024, regarding finding of no violation DPW 24-009. And may I, Bethany or Ashley, check if we have any public testifiers for this agenda item?
No public testifiers, Chair.
Thank you. And if I can have the parties appearing, please introduce themselves, starting with appellant Mr. Belisario. Thank you.
Mr. Belisario, can you please turn on your mic and introduce yourself one more time for the record? Thank you.
Joaquin Belisario, appellant.
Thank you. For the department?
Deputy Corporation Counsel Sinclair Solis Ferguson for Public Works.
Thank you. At this time, I will note that the board did receive the written testimony also from Mr. Belisario yesterday.
Chair, I think Mr. Belisario's attorney is also online, Ms. Haig.
Oh,
Hi, I'm his limited counsel attorney, Sierra Haig, appearing via Zoom.
thank you for your introduction. So today we're here to adopt the form of the order to dismiss. And if I may ask the board members if everyone has read the proposed findings of facts, conclusions of law, decision and order granting Public Works motion to dismiss submitted by DPW's counsel, as well as the appellant's objections and comments received.
Yes.
I have affirmation that all board members acknowledge that they've reviewed all of the documentation. At this time, I am entertaining a motion to approve the proposed order to dismiss as stated or with any amendments.
I move to approve the form of the order with the following amendment. I believe that a different person will have to sign as chair. I don't know how to do that. I guess we'll talk about that during the discussion, but other than that, I would move to adopt the form of order.
Or do I need a second first?
Yes.
So can I get is there a second
I'll
on?
second it.
So we have a
Second.
motion by Kathy Lewis and a second by Lisa McNamara on that motion. If I may offer to correct, and it should be also corrected in addition to the motion, the designation of the term interveners on the form of the order, if that can be corrected to state landowners. So we have a motion on the table.
Chair, I'm sorry, Deputy Corporation Counsel Sylvia Wan. Chair, are you offering a suggestion for a friendly amendment to Ms. Lewis, who is the mover?
Yes.
Thank you.
I second.
Well, I'm sorry, I think Ms. Lewis would have to adopt that.
Yeah.
And
If you-
I do adopt that. I do adopt that, and I'm not sure the protocol here, but it does say proposed on the one that I'm in possession of in two places. I don't know if we were provided with one that doesn't say proposed, but
no,
obviously.
you do not, because at this point, the filing before you is just proposed, kind of like a draft. Once the board approves, me as your counsel would basically redraft based off of your approved language, and the word proposed would be dropped as a matter of administration. So, but at this point, to your question, if you would like to adopt that friendly amendment, can you please move to adopt said amendment? And then we can move forward.
So I move to adopt the friendly amendment and thus the proposed order as amended.
Second.
And there was a second by
I'll second it. Lisa McNamara.
Martin on that.
Okay.
Any discussion by board members
On the amendment.
on the amended motion?
Mm,
Seeing none, can we go to vote, Bethany?
Chair, on the motion to approve the order with amendments as stated.
Sorry. It's just a motion to amend.
So we're only voting on the amendment, then we'll go back into discussion on the corrected motion.
Understood. Thank you. On the motion to amend, Board Member Kathy Lewis.
Aye.
I'm sorry, on the motion to approve the order.
No,
It's a motion to approve the amended motion by Kathy Lewis.
Okay, motion to approve the amended order by Kathy Lewis.
Thank you. Yes.
Okay. And Board Member Lisa McNamara,
Aye.
Board Member Scott Martin,
Aye.
Board Member Rachel Abel,
Aye.
and Board Member Stacy Aguiar.
Aye.
Chair,
So
motion
that-
passes.
Thank you. So motion passes on the amended motion. And now we're back in deliberation on the amended motion.
the motion as amended. Chair, if it would help facilitate, I'll restate
Yes, please.
Ms. Lewis's motion as it presently is amended. My understanding, and please, Ms. Lewis, correct me if I'm wrong. The motion on the table is that the board approves the proposed findings of fact, conclusion of law, and decision and order granting Public Works motion to dismiss with the following amendments. First amendment, that the chair be at the signatory line be adjusted and reflect the appropriate chair at this time, which I believe would be the chair pro tem. And second would be removal of the word interveners and insertion of the word landowners in its stead. Is that correct?
Yes.
Okay. That is up for discussion for the board presently.
Any comments from the board or discussion? Seeing none, can we take a vote on the motion?
On the motion to approve the proposed findings of fact, conclusions of law with amendments, Board Member Kathy Lewis,
Aye.
Board Member Stacy McNamara.
It's Lisa McNamara. Aye.
Sorry, Lisa McNamara, thank you. Board Member Rachel Abel,
Aye.
Board Member Stacy Aguiar,
Aye.
and Board Member Scott Martin.
Aye.
Chair, motion is approved.
Thank you. So motion passes. Thank you, Mr. Belisario. Thank you to the department for appearing. The final form of the order will be distributed by our Corporation Counsel, Sylvia Juan, to all parties.
Yes, Deputy Corporation Counsel Sylvia Juan. So I'll be tasked with making the amendments to the order as approved by the board. And I will circulate for chair's signature, which would be the chair pro tem today. And once that is signed, we will file that and provide a copy to all parties. Thank you.
Thank you. So moving on to item number 2 or 3 on our agenda, Beverly Maragos, PLBOA 2024-000112. Order to dismiss appeal of decision by the Director of Public Works dated June 20th, 2024 regarding issuance of permit number 25910 to work within the county right-of-way. Ashley, or I'm sorry, Bethany, do we have any public testifiers at this time?
No public testifiers.
Thank you. If I may ask for the appearances. The appellant is not present, and for the appellee,
Deputy Corporation Counsel Sinclair Salas Ferguson for the Public Works.
thank you. So we're here today to adopt the form of the order to dismiss. Has everyone read the proposed order to dismiss submitted by DPW's counsel and the appellant's objections?
Yeah.
Yep, all board members acknowledge they have read all the documents. At this time, I'm entertaining any conversation or motion to approve the proposed order to dismiss as stated or with any amendments.
I'll move to adopt this order, and with the only amendment being to again reflect the proper chair on the signature block.
We have a motion by Kathy Lewis. Do we have a second?
Rachel Abel, Chair. I second.
Thank you. So we have a motion on the table to adopt the proposed order with an amendment to the signature of the pro tem chair. Any discussion? Seeing none, if we can go to vote, Bethany.
On the motion to adopt the proposed order with amendments, Board Member Kathy Lewis,
Aye.
Board Member Rachel Abel,
Aye.
Board Member Scott Martin,
Aye.
Board Member Lisa McNamara,
Aye.
and Board Member Stacy Aguiar.
Aye.
Chair,
That,
motion passes.
Oh, sorry, go ahead.
Motion passes.
Thank you. So the motion passes, and if I may ask the prevailing party to issue the, or go ahead, Ms.
So the
Juan.
motion passes at this time. Deputy Corporation Counsel Sylvia Juan, at this time, I, as the board's attorney, will make the necessary adjustments as approved by the board and circulate for the Chair Pro Tem signature. Once that has been effectuated, it will be filed and provided to the parties.
Thank you. So that concludes case number 3. And if we can move on to case number 4, Andrew Tepper, PLBOA 2024-000113, proposed order rejecting defective petition, appeal of decision by the planning director dated June 25th, 2024 regarding notice of violation and order PLPCV 2023-00567 relating to unpermitted event, falls of fire, and overnight accommodations. Bethany, do we have any public testifiers on this agenda item?
No public testifiers.
Seeing none, can we then ask for the appearances, starting with the appellant? And the appellant is not present. On to the planning department.
The planning department is also.
Sorry, planning department is not present. So board, we are here to adopt the form of the order rejecting the defective petition. Has everyone had the opportunity to read the proposed order submitted to the board by council? And we have affirmation that board members have read all documents. We're now open for conversation or a motion on the adoption. Can I get a motion from anyone?
I move we adopt the proposed order.
So that was a first motion by Kathy Lewis. Do we have a second?
Rachel Abel, I second.
Any discussion on this motion? Seeing none, can we take a vote, Bethany?
On the motion to adopt the proposed order, Board Member Kathy Lewis,
Aye.
Board Member Rachel Abel,
Aye.
Board Member Scott Martin,
Aye.
Board Member Lisa McNamara,
Aye.
and Board Member Stacy Aguiar.
Aye.
Chair, motion passes.
Thank you. That concludes agenda item number 4. Now on the agenda, if we can move on to adoption of or approval of meeting minutes for the January 10th, 2025 Board of Appeals hearing. Do we have any public testifiers on this agenda item at this time?
No public testifiers.
Thank you. Have all board members read the January 10th, 2025 meeting minutes and ready to proceed? We have acknowledgement. Can I get a motion to approve the January 10th, 2025 meeting minutes?
Make a motion to adopt the January meeting minutes.
We have a
I'll
motion
second
by
that.
Scott Martin. Do we have a second?
I'll second that. Lisa McNamara.
Great. So any discussion? Seeing none, if we can take a vote, Bethany, on adoption of the January 10th, 2025 meeting minutes.
On the motion to adopt, Board Member Scott Martin,
Aye.
Board Member Lisa McNamara,
Aye.
Board Member Kathy Lewis,
Aye.
Board Member Rachel Abel,
Aye.
and Board Member Stacy Aguiar.
Aye.
Chair, motion passes.
Thank you. So moving on to administrative matters. Next on our agenda is election of both chair and vice chair.
Well, just a point of correction. Currently, the agenda says election of vice chair for 2025. I will just note for the record that since the submission of the agenda item, the board's chair has resigned. So at this time, the board, if the board is willing to entertain both the election of a chair and vice chair, the board would need to move to amend the agenda to reflect that. And you can do so at this time. It would take a 2/3 vote of those present in order to amend the agenda.
I make a motion, Lisa McNamara, I make a motion to amend the agenda for the election of both the chair and the vice chair for 2025.
Second.
Great. Any discussion on this motion to amend the current agenda? Seeing none, can we take a vote on the amended agenda to include voting in of a new chair?
On the motion to amend the agenda, Board Member Lisa McNamara,
Aye.
Board Member Scott Martin,
Aye.
Board Member Kathy Lewis,
Aye.
Board Member Rachel Abel,
Aye.
Board Member Stacy Aguiar,
Aye.
Chair motion passes.
Great. So our agenda is amended, and now the floor is open for nominations for a new BOA chair and vice chair. Anyone have any? And you can self-nominate. I'd like to nominate Kathy Lewis as chair.
I
And
don't,
go ahead, Kathy.
maybe I'm speaking too quickly, but I don't accept.
Kathy, would you entertain vice chair nomination?
If we have a chairman,
Is anyone else?
Is anyone else interested in being chair?
I would nominate Scott Martin.
So Scott declines the nomination. Lisa or Rachel?
I don't have time to do it this year. I'm going to decline.
So we've got a whole bunch of declines for chair. All right. Deputy Corporation Counsel Sylvia Wan. So I noted that all 4 members who would be here after today's meeting have declined the position of chair. What that would mean is that this board does not have a chair. And the board can nominate basically a chair for the day, like we did today with Ms. Aguiar. However, it would sufficiently cripple the abilities of this board to operate in between hearings, because we do need to have a chair in order to hold pre-hearing conferences, as well as granting non-substantial motions relating to evidence, as well as subpoenas. So there really is a need for this board to have a chair. If the board is not willing to consider at this time who should be the chair among the available members, we can pass this item on to next month's agenda. But we do need to have a chair, because effectively without one, the board cannot do its administrative tasks in between the meetings.
Could we at least vote on a temporary chair if all parties decline. If it's a temporary chair and you don't like the job, you could at least experience a little bit of it. And
So that's a possibility, since we do have this now on the agenda. Would anybody be willing to be chair pro tem through at least next month's meeting, which is March? I will note for the record that we will not be having an April meeting because one, this particular room where we are usually set is currently unavailable, as well as the two directors that would otherwise be present, need to be present for hearings, are also unavailable. So our April meeting will be canceled. So our next meetings are March and May.
Both
so,
in Hilo.
Both of those are in Hilo, yes.
so Sylvia, my position is a holdover until the March meeting. So I will be attending the March meeting. What is the date of the March meeting?
March 14th.
So do we have to nominate a chair pro tem for the March meeting, or how about a vice chair who could be acting chair?
Those are both options that the boards can consider.
I'm willing to keep this board going for a while, and maybe Stacy can do it. I mean, are we in a discussion phase right now?
Yes, I mean, we're in nomination, so we're sure it's discussing. I am willing to do chair pro tem for my last meeting, which is March, to give the rest of the board members more time to reconsider, being that I think we are short two members at this time, and after March, you will be short 3 members if no one is appointed by them.
So I would be willing to pick up April. I'd like to see Scott try it though. Scott, are you steadfastly in your position?
Yes, I don't have the time to devote. Thank you, though.
So I'm willing to do April, but I'm just wondering what steps can be done to get us some more members, or we're going to have a constitutional crisis here.
Deputy Corporation Counsel Sylvia Wan. So I will note that your board staff has been working with the mayor's office to actively, politely persuade them to get more applicants for these positions. I believe they are considering someone presently. However, it is not to the stage of a nomination yet, so it's a bit early. We have let them know that we are going to be losing Stacy very shortly. So they are aware of our position. We can only move as fast as we can move. Thank you. So, can we get some motions? I hear some willingness at least.
So I make a motion to be acting chair through the March meeting, Stacy Aguiar.
Rachel Abel, I second that motion.
Any discussion on the motion? Seeing none, can we take a vote?
On the motion for acting chair through March meeting, Stacy Aguiar.
Aye.
Board member Rachel Abel.
Aye.
Board member Kathy Lewis.
Aye.
Board member Scott Martin.
Aye.
And board member Lisa McNamara.
Aye.
Chair motion passes.
All right, so we still have an open vacancy for vice chair.
Well, I believe you might have another motion from Board Member Lewis regarding up to April.
Well, if you want me to do it now, I can.
That would be preferred, just so we have some stability. So that the board staff has some stability.
Okay, so I move that myself, Kathy Lewis, serve as pro tem chair for the April meeting.
Okay, thank you. Deputy Corporation Counsel Sylvia Wan, would you be willing to do that through the May meeting since the April meeting is not going to happen?
Oops, I meant to say May. I misspoke. Sorry.
Thank you.
So I moved that due to the fact that the April meeting is not going to be held, that I would serve as chair pro tem at the May board meeting.
I second Kathy Lewis's nomination for chair pro tem through May. Any discussion by board members? Seeing none, if we can take a vote.
Well, I do have a quick discussion. Can we just sort of agree without it being part of the motion that Stacy can do pretrial motions or, any pretrial issues up until the meeting that she will chair, and then I can do the pretrial if anything happens up until the May meeting that I'll chair.
Sure.
Deputy Corporation Counsel Sylvia Wan, that is what I was anticipating. That there would be a handoff after the March meeting from Stacy to you as far as the pretrial requirements. Thank you. Or pre-hearing requirements.
Any more discussion on that? Seeing none, can we take a vote?
On the motion to nominate Kathy Lewis as pro tem through the May meeting. Board Member Kathy Lewis,
Aye.
Board Member Rachel Abel,
Aye.
Board Member Scott Martin,
Aye.
Board Member Lisa McNamara,
Aye.
Board Member Stacy Aguiar,
Aye.
Chair motion passes.
Great. We now have chairs in place through May. If we can move on to a status of appeals filed with the board by Corporation Counsel.
At this time, there's nothing further to update the board with. Everything is status quo.
Great. Any outstanding petition updates from the staff?
No
Seeing
updates.
none. Any announcements, anyone?
Happy Valentine's Day.
Oh, happy Valentine's Day. I will now make a motion or entertain a motion for adjournment.
I'll second it.
I need a motion first. Are you, Lisa McNamara motions to adjourn? Can I get a second?
I'll second that motion.
Great. Any discussion? Seeing none, all in favor of adjourning this meeting? Aye.
Aye.
We have
Aye.
a unanimous yes, and the meeting is adjourned. That concludes today's BOA hearing. Thank you.
Great.
Thank you.
Sleep.